at the outset, I would like to thank the program coordinator and the university for having me here and giving me this opportunity to share my thoughts on privacy in cyberspace with this eminent gathering. So, privacy in cyberspace. Before coming to the core issues of cyberspace, I would like to take you through the idea of privacy, or the concept of privacy rather. So when we talk about privacy, it means many things to many people. Privacy के बारे में एक individual perspective है. So in its simplest sense, it allows each human being to be left alone in a core which is inviolable. So when we talk about privacy rights, there could be individual perspective, there could be community perspective, perspective relating to cultural aspects is also associated with this. There are certain scholars who have shared their thoughts, their mind about the privacy. One of them is Aristotle. हम लोगों ने इनके बारे में सुना हुआ है. So he says that the distinction between the public and private realm can be regarded as providing a basis for restricting government authority to activities falling within public realm. So when we are talking about the privacy rights, so what are the rights which are to be protected? One, then in what situations government may interfere with these rights, and sometimes not only the government, even individuals try to encroach upon the privacy of other persons. So in what situations it may be allowed, and in what situations the privacy of an individual should be respected. So when we look at the development of right to privacy, so first it was an article was written by American lawyers Samuel D. Warren and Louis Brandeis. In that article, the title of the article was "The Right to Privacy." It was published on 15 December 1890 in the Harvard Law Review. The article described the right to life as a recognition of man's spiritual nature, of his feelings and his intellect. That is to mean the right to enjoy life, which includes the right to be left alone or right to let alone. So when we talk about right to privacy, so this conception of right to privacy was first discussed by the Samuel D. Warren and Louis Brandeis in their article Right to Privacy.
About 80 seat.
Now there is another definition which is given in the legal dictionary, which is Black's Law Dictionary, which talks about right to be let alone, the right of a person to be free from.
Okay.
May I request to help the background noise, please? The Black's Law Dictionary, which is a legal dictionary, describes the right to be let alone, the right of a person to be free from unwarranted publicity, the right to live without unwarranted interference by the public in matters with which the public is not necessarily concerned. So these are some of the definitions of the right to privacy. And one more thing that we have to remember, that when we talk about right, that means the moment we say right, it means there is remedy. So if our privacy rights are getting violated, we have a remedy. That means we can go to court and get it enforced. So Article 12 of Universal Declaration also talks about privacy rights, and it states that the privacy rights cannot be taken away in arbitrary manner or by way of unlawful interference. And it states that the privacy here includes family, home, and correspondence, not to unlawful attacks on his honor and reputation. Everyone has right to the protection of the law against such interferences attacks. So where somebody's right to privacy is being infringed, so that has been discussed in the international documents as well, international covenants as well. Article 17 of International Covenant of Civil and Political Rights also talks about no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, and correspondence, nor to unlawful attacks on his honor and reputation. Everyone has right to the protection of the law against such interferences or attacks. So we will discuss few cases where the police or the law enforcement was making domiciliary visits to the home of an accused, and the law which permitted such domiciliary visits was declared to be unconstitutional by the Supreme Court. Similarly, when it comes to correspondence, like emails are under surveillance, letters are under surveillance, communications are being intercepted and heard. So in all those cases, what would be the role of law? How it would come to protect the right to privacy of the individuals? Then European Union, Article 8 of the European Convention on Human Rights, it also talks about the protection of right to privacy. It states that everyone has right to respect for his private and family life, his home, and his correspondence. So there shall be no interference by a public authority except such as in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the protection of health or morals, or for the protection of the rights and freedom of others. So this particular convention also advocates for the promotion of privacy rights as human rights, and it states that any government shall not interfere with the privacy rights of individual unless that individual is doing something which would have bearing on the national security, which would have bearing on the democratic society, democratic values, which would have bearing on the rights of other persons, or a person is doing something anonymously. We will discuss about the concept of anonymity as well. So somebody is posting something anonymously, pseudonymously about a government, about a public authority, about an individual, which is defamatory, unlawful. So in all those cases, privacy of such persons, maybe privacy rights of such persons may be taken away. Now, when we look at the Constitution of India, it also states that no person shall be deprived of his life or personal liberty, excepting according to the procedure established by law. So here it uses few phrases which are very important. His life. What is meant by right to life? So courts in several decisions, several judgments, courts have clarified this. Right to life means glorified life. Garima mein jeevan. It is not a life which is not glorified. That means where privacy rights have been taken away. And courts have also stated that without right to privacy, right to life cannot be thought of. Because if you remove the right to privacy from right to life, or in other words, we may say that right to life minus right to privacy, then that may not remain glorified life. Anybody may enter in your home, anybody may intercept your communication, may read your letters. So that is not the glorified life. And one more thing that we have to bear in mind, that right to life when we are talking about right to privacy, which is enshrined under Article 21 through a series of judgments, and after Puttaswamy judgment, now it has been declared to be a fundamental right. So this right to privacy is not absolute right. राइट टू प्राइवेसी एक ऐसा राइट नहीं है जो कि आपको स्टेट के अगेंस्ट में उपलब्ध है और उसको उसमें किसी प्रकार का इंक्रोचमेंट नहीं हो सकता है. So no, even when we talk about fundamental rights, so these rights are not absolute rights. So state has power to make rules and to put reasonable restrictions on these rights. Suppose that somebody is posting defamatory content against a person or defaming the state, and he is doing that by being anonymous. वो फेसबुक में एक अकाउंट क्रिएट करता है और एनोनिमसली पोस्ट करता है जहां पर उसकी आइडेंटिटी नहीं है. ऐसे में that the person who is posting these kind of messages would say that this is my right to anonymity, which is part of right to privacy. So should that right be upheld? Should that right be respected? So if it is interfering with the life of others, if it is unlawful, in that case, that anonymity could be dig out. उस anonymity को uncover किया सकता है, and that person may be prosecuted as per the law. So whenever right to privacy is to be taken away, it cannot be taken away in arbitrary manner. जैसे किसी के ईमेल को सर्विलांस पर रखना है, तो आर्बिट्रेरी मैनर में नहीं किया सकता. ये डॉक्यूमेंटेड होना चाहिए, अकॉर्डिंग टू लॉ होना चाहिए. So that's why, according to the procedure established by law. So what is the procedure? So वो आप देखेंगे कई हमारे पास कई तरह के कानून हैं. सब्जेक्ट मैटर रिलेटेड कानून है. सपोज दैट लेटर है तो दूसरा कानून होगा, ईमेल है तो दूसरा कानून होगा, टेलीफोन है तो हमें टेलीकॉम लॉज में जाना पड़ेगा. तो अगर इस तरह की कोई इंटरसेप्शन हो रहा है तो उसके लिए जो प्रोसीजर बनाया गया है लॉ में, दैट प्रोसीजर मस्ट बी फॉलोड. बिना प्रोसीजर को फॉलो किए अगर किसी के राइट टू प्राइवेसी के साथ कोई इंटरफियर किया जाता है, देन दैट वुड बी वायलेशन ऑफ द लॉ. और वो चाहे कोई वो अगर स्टेट कर रहा है तो या स्टेट की एजेंसीज कर रही है तो वो भी इस कानून के तहत लायबल होंगी. तो आर्टिकल 21 is the we can say that mother of all the privacy laws in India. अब अगर हम प्राइवेसी लॉज, प्राइवेसी कॉन्सेप्ट की बात करें तो बहुत सारे जजमेंट हुए हैं इसमें, और कई केसेस में राइट टू प्राइवेसी को फंडामेंटल राइट पहले भी माना गया है, पर पार्टली, और पुट्टास्वामी जजमेंट के बाद इसको फंडामेंटल राइट डिक्लेयर किया गया है. सो एज आई वाज डिस्कसिंग अर्लियर, एरिस्टोटल से शुरू होता है, सैमुअल वॉरेन एंड लुइस ब्रैंडिस आर्टिकल लिख करके राइट टू privacy concept को propagate करते हैं, and then there are other contributors who have written and who have deliberated on the right to privacy. अब अगर हम जोन्स ऑफ प्राइवेसी की बात करें कि कौन कौन से प्राइवेसी की क्या क्या जोन्स हैं, so we will find that one is solitude, the most complete state of privacy involving the individual in an inner dialogue with the mind and conscience. कोई व्यक्ति अकेले रहना चाहता है तो क्या ये उसका राइट है? क्या उसको ये राइट दिया जा सकता? क्या ये उसकी प्राइवेसी राइट्स में आएगा, राइट में आएगा? जैसे कोई व्यक्ति कहता है कि मैं ध्यान करना चाहता हूँ, योग करना चाहता हूँ, अकेले रहना चाहता हूँ, तो क्या ये राइट टू प्राइवेसी में आएगा कि नहीं आएगा? सो दिस इज वन ऑफ द जोन्स ऑफ द राइट टू प्राइवेसी. देन इंटीमेसी. It refers not merely to intimate relations between spouses or partners, but also between family, friends, and colleagues. So a person has this right. No one can interfere in these rights without the authority of law, without following the procedure established by law. Then anonymity. An individual seeks freedom from identification and surveillance despite being in public space. Therefore, desire for public privacy. जैसे कोई व्यक्ति एनोनिमसली क्यों कुछ लिखना चाहता है या कुछ बोलना चाहता है या कुछ पोस्ट करना चाहता है, There are several reasons behind that. One, he or she does not want to come to the public. Second, he wants to speak his or her mind, but he is afraid of sanctions. He is afraid of superior authorities. He is afraid of government. He is afraid of certain influential persons of the society. So what he can do or she can do, they start writing anonymously. So right to anonymity is also protected. It is because it promotes human rights. For example, if a person who wants to speak his mind, वो अपनी बात कहना चाहता है, suppose that उसको गवर्नमेंट की एक पॉलिसी के अगेंस्ट में बोलना है, अपने कंपनी के, अपने ऑर्गेनाइजेशन के किसी पॉलिसी के अगेंस्ट में बोलना है, and he is working over there, so it may not be possible for him. He or she may not afford to speak his mind. So what he does, he chooses or she chooses anonymity. वो एनोनिमस रह करके अपनी बात रखते हैं, जहां पर उनकी आइडेंटिटी को डिस्क्लोज नहीं किया जाता और वो अपनी बात भी कह देते हैं. अब यहाँ पर एक हमें ध्यान रखना होगा कि एनोनिमिटी की जब हम बात करते हैं तो कहाँ तक अलाउड है ये. When somebody is speaking something which is lawful, which does not encroach upon the rights of others, up to that extent right to anonymity shall be upheld. लेकिन अगर कोई व्यक्ति एनोनिमस रह करके किसी को डिफेम कर रहा है, किसी के खिलाफ डिफेमेटरी पोस्टिंग्स कर रहा है, गलत बातें लिख रहा है, तो उस केस में दी लॉ एनफोर्समेंट shall have power to know about such person. और उसके लिए मान लिया कि वो फेसबुक प्लेटफॉर्म का इस्तेमाल कर रहा है, तो लॉ एनफोर्समेंट फेसबुक को लिख करके ये जानकारी मांग सकता है कि ये किस व्यक्ति का अकाउंट है, कहाँ से ओपन हुआ है, और उसकी एनोनिमिटी को डिस्क्लोज कर सकता है. तो एनोनिमिटी की जब हम बात करते हैं, ये राइट तो है, बट इट हैज इट्स ओन लिमिटेशंस लाइक एनी अदर राइट. But in normal course, this right would be available to the individuals. Reservation, the need to hold some aspects of ourselves back from others, either as to personal and sacred or as to shameful or profane exposes. Now, a person has every right not to express his mind about a particular subject matter. So, जब हम राइट टू फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन की बात करते हैं कि फ्रीडम ऑफ स्पीच, तो उसमें राइट टू कीप साइलेंट ये भी शामिल है. चुप रहने, बोलने के अधिकार में चुप रहने का अधिकार शामिल है. अगर कोई व्यक्ति चुप रहना चाहता है किसी विषय पर, किसी मुद्दे पर, उसके बोलने के लिए फोर्स नहीं किया सकता. किसी विषय पर उसे अपनी ओपिनियन देने के लिए बाध्य नहीं किया सकता. However, there are certain exceptions to this rule. कि कोई व्यक्ति किसी लीगल प्रोसीडिंग में है, कोर्ट में है, और वो विटनेस है किसी इंसिडेंट का, तो वो ये नहीं कह सकता कि नहीं, ये तो मेरा चुप रहने का अधिकार है, मैं अपनी बात नहीं कहूँ, मैं नहीं बोलूंगा. लेकिन आपने देखा है कि एक्यूज्ड को भी ये राइट है कि वो अपनी किसी जो भी उसने अपराध किया हुआ है, वो अपने खिलाफ गवाही देने के लिए बाध्य नहीं किया सकता. तो जब हम राइट टू प्रिवेसी कॉन्टेक्स्ट में बात करते हैं, तो यहाँ पर ये अधिकार भी राइट टू प्रिवेसी के अंतर्गत उपलब्ध है इंडिविजुअल्स को. We have discussed these issues from solitude to intimacy to anonymity to reservation, and then we see that when we talk about personal zone, intimate zone, semi-private zone, public zone, so we see what kind of rights are being claimed. Bodily privacy, शारीरिक निजता. Nowadays we see the instances because of the evolution of the technology. Every mobile phone has camera. Now there are people who tend to capture the images of the image of the other person, and public and sometimes we see that hidden camera is installed in trial rooms of shopping malls, public toilets, hotels, जहां पर एक व्यक्ति की रीजनेबल एक्सपेक्टेशन है अपनी बॉडली प्राइवेसी का, अपनी शारीरिक निजता का, वहां पर उसके निजता के अधिकारों का उल्लंघन हो रहा है. स्पेशियल प्राइवेसी, कम्युनिकेशन प्राइवेसी, प्रोप्राइटरी प्राइवेसी. कम्युनिकेशन प्राइवेसी का मतलब है कि जो भी हम करेस्पॉन्डेंस कर रहे हैं, चाहे वो ईमेल्स हो, चाहे वो किसी अन्य माध्यम से हो, उसकी सैंक्टिटी मेंटेन होनी चाहिए. Then when we talk about the other kind of privacy, we see that intellectual privacy, decisional privacy. So decisional privacy, some decision has been taken. Now that must not go to public without following the proper course. For example, a decision has been taken by a committee and that goes out. A result is to be declared. That result is to be declared by a particular department of the university. That must not be declared by any other person who is not authorized to do that. Behavioral privacy. So there are many aspects of the privacy. Now, when we look at the broad categories of the privacy, then we find that the spatial privacy, the privacy pertaining to physical spaces, bodies, and things, the privacy of certain significant self-defining choices, and informational privacy, as we discuss about the personal information communication that one person is making with another person. And here the concept of data protection comes out. कि अगर इस तरह से, because when we make communication with the help of information and communication technologies, then whatever we are communicating, that is traveling in the form of data. So that data must be protected. That data must be protected at the, during the time of transit as well as storage. Now, when we talk about informational privacy, so a Supreme Court of India observed in Puttaswamy judgment that informational privacy is a facet of the right to privacy. The dangers to privacy in the age of information can originate not only from the state, but from the non-state actors as well. We recommend to the union government the need to examine and put into place a robust regime for data protection. The creation of such regime requires careful and sensitive balance between individual interest and legitimate concerns of the state. So it basically directs the state that there must be a robust system for the protection of data, because as I said earlier, that now, because we are using technology in every walk of life, so everything is being converted into the form of data, and that data is required to be protected. Now, I would like to take an example of Uber. Uber, when you take a ride of Uber, and you, so it basically collects certain information. That app collects certain information about you. Uber की राइड लेने के बाद आप मान लिया कि किसी एक जगह पर जो आपका डेस्टिनेशन पॉइंट है, वहां आप कार से उतर जाते हैं एंड यू गो अवे, आप अपने डेस्टिनेशन की तरफ वॉक करते हैं. टेक्निकली ऐसा लगता है कि हमने उबर की ड्राइव हमारी क्लोज हो गई, नाउ दैट एप्लीकेशन इज नॉट वर्किंग, बट दैट एप्लीकेशन इज स्टिल मॉनिटरिंग योर फुटप्रिंट्स at least till 5 minutes, or maybe as it may be defined. And what does it do? It collects data कि ये व्यक्ति यहाँ पर इस पॉइंट पर उतर कर कहाँ जा रहा है, क्या ये दूसरी टैक्सी ले रहे हैं, क्या ये बस में जा रहे हैं, रेलवे स्टेशन पे जा रहे हैं. इस तरह की डेटा वो कलेक्ट करते हैं. The question is, do we authorize Uber to collect this kind of data? Uber says yes. How? The click wrap agreement. जो एग्रीमेंट का फॉर्मेट है उनके, उसमें बहुत सारे टर्म्स एंड कंडीशंस लिखे हुए हैं, और मोस्ट ऑफ अस व्हेन वी डाउनलोड एन एप्लीकेशन, तो हम लोग आई एग्री या फिर आई क्लिक करके उसके सारे टर्म्स एंड कंडीशंस को एक्सेप्ट कर लेते हैं. उसमें क्या क्या लिखा हुआ है, समटाइम्स वी डू नॉट रीड इट. सो वी आर एग्रीइंग टू, वी आर गिविंग अवर कंसेंट टू उबर टू डू दिस. साउथ अफ्रीका में एक रिपोर्ट पब्लिश हुई एक न्यूज़पेपर में, and that was based on the data which was obtained from Uber analysis. The data was that those who are taking cab after 10 p.m. after drive off, कार से उतर करके, most of them are going to the brothel. Now this made lot of noise कि कोई व्यक्ति उतर करके कहाँ जा रहा है. Uber has no business to analyze that, but Uber was doing that. So this has a bearing on the privacy of the individuals. So these kind of applications which are collecting data, processing the data, utilizing it for their own purposes, as well as sometimes they are selling it to the ad agencies and making money out of it by breaching the privacy of the individuals. Now, the question arises, why to protect data? Uber का एक example है, इसी तरीके से Facebook and other applications, they do collect data about individuals. So when we talk about data-driven innovation, so now data is being considered as an asset. Data is something which is valuable, which could be bought and sold. To ensure that digital future of India is committed to 3 E's, that is empowerment, experiment, that is research and development, and equal access to all its citizens. So this flow of data should be there, but at the same time, it must be in a controlled way. It should not be like that an entity is collecting data and then using it in any manner. There are many agencies who are which are collecting data from the Facebook. For example, Facebook's 10 years challenge. अगले जन्म में आप क्या बनेंगे? 10 साल बाद आप कैसे दिखेंगे? What they are doing? They are basically asking for data. So a person who participates in Facebook's 10 years challenge, या 20 साल बाद आप कैसे दिखोगे? पिछले जन्म में आप क्या थे? So now earlier people used to go to astrologer to know all these things. Now Facebook would do it for those people. तो यहाँ पर बहुत सारी इंफॉर्मेशन वो कलेक्ट कर रहे हैं. जैसे ही अगर आप इन सब चैलेंजेस में पार्टिसिपेट करेंगे, आपको बहुत सारा डेटा अपने बारे में शेयर करना होगा. इस डेटा का क्या कर रहे हैं वो आपको कुछ डेफिनेटली दे आर गिविंग सम आउटपुट कि आप ये थे और या अगले जन्म में ये बन जाएंगे, पिछले जन्म में ये थे, बट उसके साथ ही उस डेटा का हो क्या रहा है. So that data is being sold to various companies and they are processing that data for their own purposes. Not only that, there was a Sri Lankan firm who used to pick the photographs of good looking women from the Facebook and would sell it to the pornographic websites and they will use it. So these are the misuses of the data. And since huge data is being collected, huge chunk of data is being collected by these service providers. So how do they analyze it? So they are using machine learning algorithms to analyze the data, to segregate it, and to so that they should be able to make use of it. So data can be put to beneficial use. The unregulated and arbitrary use of data, especially personal data, has raised concerns regarding the privacy and autonomy of an individual. What is the data that should be collected about me? I as an individual, I have every right to decide that. So no unnecessary data should be collected about me without my permission. Now there are different classes of data that we will discuss in coming slides. So the data protection regime tries to regulate these behaviors and tries to put in place a regulatory system which would address the issues relating to data leakage. So collection, processing, and analysis of personal data. Now, what we see in the process of collection, profiling of individuals. A person is visiting a particular website. Suppose that an individual started from Google. He typed a keyword in Google and then he went to certain websites. Now his digital footprints are being collected. And then on the basis of that, a profile for that particular person is being prepared. And accordingly, he starts receiving emails, he starts receiving advertisements. Similarly, surveillance. Like one example, we were discussing about Uber. There are many other applications which would collect your locational information. आप अभी कहाँ पर हो, आप कहाँ से कहाँ जा रहे हो. अगर suppose that कि आपने Google Map इंस्टॉल किया अपने मोबाइल फोन में, आप कार में अपने बैठते हैं, it tells you 20 minutes it will take 20 minutes to reach to home. आपने कुछ नहीं किया, आपने कोई मैप में सेटिंग नहीं की है, बट यू हैव अलाउड, आपने गूगल मैप में कुछ परमिशन दे रखी हैं. सो आपको लगता है कि मैं गूगल मैप नहीं यूज कर रहा हूं, बट गूगल मैप इज रनिंग इन द बैकग्राउंड एंड इट इज कलेक्टिंग इंफॉर्मेशन. इट इज आल्सो मॉनिटरिंग योर फुट स्टेप्स. आप कहाँ जा रहे हो, किस लोकेशन में जा रहे हो. Everything is being collected and then it is being processed and sold in the relevant market. क्रिमिनल इन्वेस्टिगेशन में भी हमने देखा है इसका बहुत उपयोग होता है, दोनों के लिए, क्रिमिनल्स के लिए, लॉ एनफोर्समेंट के लिए. एक केस में एक पुलिस टीम एक एक्यूज्ड को अरेस्ट करती है. उन्होंने पुलिस, अब डिस्प्यूट कोर्ट में इस बात पर था कि उसे अरेस्ट कहाँ से किया गया. एक्यूज ने कहा कि मुझे, फॉर एग्जाम्पल इन हाइपोथेटिकल सिचुएशन, एक्यूज ने कहा कि मुझे इंदौर से अरेस्ट किया गया और पुलिस कह रही नहीं, हमने इनको भोपाल में अरेस्ट किया. Then the defense lawyer produced the call, the mobile locations of the police officers with the permission of the court, and the location of all the police officers were shown in Bhopal at that point of time. किसी का भी लोकेशन इंदौर में नहीं था. तो एक्यूज्ड का जो पॉइंट था कि मुझे इंदौर में अरेस्ट किया गया और मेरी अरेस्ट को भोपाल में दिखाया जा रहा है, दैट कुड बी जस्टिफाइड थ्रू दिस एविडेंस. सो ये it is being used in law by the law enforcement, in legal proceedings. That is one aspect of it from the like evidence के रूप में. In addition to that, the many corporate houses, they are collecting data, they are keeping surveillance over user behavior, and then making writing promotional emails or making personalized offers to individuals. And this has a bearing on the individual's autonomy. Individual's autonomy means a person has a right to decide that what data, what information about him is to be shared with public, is to be shared with a third party, and what data, what information is not to be shared. Now, when we talk about the meaning and purpose of data protection, so data protection refers to the protection of the personal information of individuals by restricting how such information can be collected, used, and disclosed. Purpose of data protection. Data protection enables an individuals to have the freedom to determine how their personal information will be collected, used, and disclosed. For example, we are downloading an application. Application में terms and conditions appear होती है एक box में हमारे सामने, and we click on that, we agree to that. So क्या purpose है? वो उस एप्लीकेशन के जो टर्म्स एंड कंडीशंस की का जो बॉक्स है उसमें लिखा रहता है और हमें पता होता है. समटाइम्स वी इग्नोर दैट, वी डू नॉट रीड दैट, बट वी गिव अवर कंसेंट टू दैट. तो यहाँ पर एक इन्फॉर्म्ड कंसेंट है, कंटेंट आपके सामने है, आपने पढ़ लिया और फिर आप कंसेंट दे रहे हैं. और उसमें क्या क्या चीजें हैं, उसमें बहुत सारी इंफॉर्मेशन हमारे बारे में कलेक्ट की जा रही है, जिसकी परमिशन हमने ऑलरेडी दे रखी है कि ये उबर हमारी लोकेशन को ट्रैक करेगा, उबर कार्स के से निकलने के बाद 5 मिनट्स तक हमें लोकेट करेगा. सो ऑल दोज परमिशंस वी डू गिव. और दूसरा एग्जांपल इसका हो सकता है, when we are downloading a bundle software. Suppose that एक वेब ब्राउजर में डाउनलोड कर रहा हूँ, इट इज बंडल सॉफ्टवेयर. इसी तरीके से कोई गेमिंग सॉफ्टवेयर में डाउनलोड कर रहा हूँ, इट इज बंडल सॉफ्टवेयर, फ्री गेम. उस बंडल सॉफ्टवेयर में क्या क्या है मुझे नहीं मालूम है, क्योंकि मैंने उसको पूरी तरीके से पढ़ा नहीं है. आई हैव डाउनलोडेड दैट एंड मे बी आफ्टर फ्यू वीक्स आई विल डिलीट दैट. लेकिन टर्म्स एंड कंडीशंस उसकी हमने पूरी नहीं पढ़ी है, बट आई हैव कंसेंटेड फॉर दैट. व्हाट इज हैपनिंग, जो गेम मैंने डाउनलोड किया उसको डिलीट कर दिया, लेकिन उसके साथ और भी जो एप्लीकेशंस इंस्टॉल हुए, एंसिलरी एप्लीकेशन जो इंस्टॉल हुए, वो अभी भी मेरे कंप्यूटर में है. इट कुड बी अ ट्रोजन, इट कुड बी स्पाईवेयर, इट कुड बी अ मालवेयर. इट मे कलेक्ट डेटा फ्रॉम माय कंप्यूटर एंड मे सेंड इट टू. in digital age, we see that information and communication technologies have revolutionized revolutionized our life. We are using many technologies, including mobile phone, laptop, wearables, many applications we have downloaded, and all these applications are collecting data about individuals and processing it, storing it. So that's why data has become an asset, and it is a valuable asset. Most of you must have seen this particular internet minute. Now, if you look at it, if I am on Facebook, LinkedIn, YouTube, and all these websites, so lot of data is being generated, lot of data is being collected, being processed, being transferred. Now the question is how to protect this, how to regulate the transfer of data, storage of data, leakage of data, disclosure of data. Because if we look at only these applications, then we can imagine how much data we are generating, and that is being collected, being processed by the third parties. So in the year 2020, the population of the world was 7.7 billion plus. Number of internet users were 5 billion. Number of smartphone users 3.5 billion. Number of IoT devices 50 billion. Data generated in 2020 was 90 gigabytes, and it is expected that by 2025 the 175 gigabytes will be created. Now, when we look at the organizations, so organizations have been discovering the ways to generate value from the data. The typical process of value creation from data we can understand from this particular data collection, then cleansing and curating raw or factual data, populating database in standardized formats, then data mining and data analysis using various tools and techniques, use curated data to train AI and ML systems. Information is converted to insight that help in prediction and decision making for revenue or profit generation. So whether browsing habit of an individual would have any value. So when this data is analyzed, a profile is being prepared, that a person who goes to Google and then he typed a particular keyword, then he goes to another website, buys something, looking for certain kind of products, is not able to buy because he's looking at the EMI options. He wants to buy this in installments. If this information has been collected, this could be converted into useful data, and then it is shared with the relevant organization, relevant company, which is selling that particular those articles, and then pinpointed advertisement could be sent to that person, pinpointed calls could be made to that person, and in most of the cases, the person who was searching for this kind of article would be convinced to buy it. So it is not like that the data, the browsing habit is a data which has no value. The only thing is that if it has been processed properly, it could be converted into beneficial data. It could be converted into a data which could be bought and sold. And when we talk about the surveillance, the kind of surveillance that government is having on the data that is flowing through the medium of internet. So former US President Carter handwritten letters to avoid US surveillance. So he writes, I have felt that my own communications are probably monitored. When I want to communicate with a foreign leader privately, I type or write a letter myself, put it in the post office and mail it rather than by sending it through an email. Few international companies are so concerned about the internet surveillance and spying in China that they were flying any China-based executives to South Korea for important phone calls to avoid tracking or eavesdropping. So the CEOs of the companies who are based in China, वो साउथ कोरिया जाते हैं फोन करने के लिए, ईमेल लिखने के लिए, इंपॉर्टेंट बिजनेस कम्युनिकेशन के लिए, बिकॉज चाइनीज गवर्नमेंट हैज ए स्ट्रॉन्ग regime of surveillance over the internet and all forms of communications, including electronic communications. So what you are talking to other person, what you are talking to your foreign counterparts, they will try to capture that. So that's why these CEOs, they travel to the foreign countries just to make a call. And even when we talk about China, they are so much, they are putting surveillance over all the activities of their citizens and the activities which is taking place on their soil. But when it comes to their own matter, they are very careful. I would like to share with you my experience. In 2017, during my visit to the US, we visited the state of the Foreign Affairs Department of the US government. So we saw the embassy of most of the countries in that particular locality, and we inquired about China. तो हमें ये बताया गया कि चाइना का अलग से बना हुआ है. They demanded a separate piece of land. उनका जो ऑफिस है फॉरेन अफेयर्स डिपार्टमेंट में यूएस के, एंड उन्होंने पूरी जो उनको जो उनको प्लॉट दिया गया था उसको उन्होंने पूरा 20 फीट तक डिग किया, बिकॉज दे हैड ए डाउट कि ये बग्ड हो सकता है, इसकी बगिंग हो सकती है. सो उन्होंने उसको डिग किया. दे ब्रॉट द ब्रिक्स एंड अदर बिल्डिंग मटेरियल फ्रॉम द चाइना थ्रू चार्टर्ड प्लेन्स टू बिल्ड देयर बिल्डिंग, बिकॉज दे हैड ए सस्पिशन कि जो दीवार में जो ब्रिक्स यूज हो रही हैं वो भी उसमें वो बग्ड हो सकती हैं, या कोई बिल्डिंग मटेरियल जो यूज करें वो बग्ड हो सकता है. सो दैट काइंड ऑफ कंसर्न इज देयर. नाउ द यूजेस एंड बेनिफिट्स ऑफ द डेटा and its value include treating data as an asset, then activity or uses value of data, future value of data, and prudent value of data. So I'm not going into detail due to paucity of time. Now I would directly come to the regulatory framework relating to the data protection. So as we discussed in the beginning, that right to privacy refers to right to be let alone, right to self-determination. When we talk about informational privacy, so this has been taken care by the Information Technology Act 2000, Section 43, capital A, read with the Reasonable Security Practices and Procedures and Sensitive Personal Data or Information Rules 2011. So there is an elaborate discussion about the informational privacy. Data protection, what about personal data or information and how it is to be protected. Then why it is important? It is important because of the digital revolution, data economy, data as an asset. Think of an IoT system where devices are connected with each other, and this interconnection would not yield any fruitful result unless it process and transfer data. So in this particular system, we see that data is flowing from one device to another device, from one machine to another machine. It is being stored, it is being processed. So if that data is not secure, if it is if anyone can collect it and store it and disclose it or misuse it. So that would have bearing on the right to privacy of the individuals. So that's why there must be a strict data protection. There must be a strict data protection regime. Does India require personal data protection law? So India is to shape global digital landscape in 21st century. It must formulate a legal framework relating to personal data that can work as a template for the developing world. I would like to take an example. There was a time when there was a boom in the BPO industry. BPO industry, because we have cheap labor in our country. So UK, US based companies, Western countries, they were getting their data processed in India through in the BPOs. Now, what was the arrangement between the Indian BPO and say a bank in UK? Arrangement was that it was a contract between the suppose that there is a bank in UK which is getting its data processed in a BPO in India. So it was a contract between the two parties. And in case of any breach of or disclosure of data by the BPO, it would be sued for breach of contract. And what would be the legal liability of the bank in UK? It would be determined as per the data protection laws. तो अगर किसी एक कस्टमर का क्रेडिट कार्ड इंफॉर्मेशन यूके की बैंक जो कि यूके की बैंक में है लीक होता है, तो दैट कस्टमर वुड बी एंटाइटल्ड टू क्लेम ह्यूज कॉम्पनसेशन फ्रॉम द बैंक. और वो बैंक इंडियन बीपीओ से क्या मांग सकती है? वो ये कहेगी कि ब्रीच ऑफ कॉन्ट्रैक्ट हुआ है, कॉम्पनसेट कीजिए. तो जो कॉम्पनसेशन का अमाउंट होगा वो बहुत ही मीगर होगा, बहुत ही कम होगा. सो बिकॉज ऑफ दिस many Western countries they stopped giving business to Indian BPOs. कि आपका data protection laws आपके यहाँ बहुत weak है. That's why we cannot part with our data. क्योंकि आपके यहाँ पर credit card information leak हो जाता है हमारे customer का, then we have to suffer. Because of this, Indian BPO industry started losing business. So what they decided that they would comply with the laws of the other countries. जैसे यूके की बैंक अगर उनको कोई डेटा दे रही तो यूके के लॉ को मानेंगे इंडियन बीपीओ, और they will surrender to the laws of the UK as well as to the courts of UK. तो अगर कोई breach of डेटा होता है, कोई डेटा डिस्क्लोजर बीपीओ के लेवल पे होता है, तो जो इंडियन बीपीओ की लायबिलिटी फिक्स होगी वो यूके लॉज के तहत होगी, और उसकी सुनवाई अब इट वुड अगेन डिपेंड ऑन द एग्रीमेंट. वो हो सकता है यूके में हो या इंडिया में हो, और जो कॉम्पनसेशन पे करना होगा एज पर द यूके लॉज. सो because these countries they were not ready to share the data, stating that कि आपके यहाँ पर adequate data protection measures नहीं है. Now the personal data protection bill is a response to this particular problem, and it basically borrows many principles from the general data protection regulation of the European Union. Now, what are the principles of data protection? Fair and reasonable processing, data minimization, purpose specification, information quality, data principle and participation, disclosure, information security, sensitivity. Principle of fair and reasonable processing. When information is collected or has been collected, it must be processed fairly, and it would be the duty of the data fiduciary to ensure that data must not be processed in unreasonable manner. I am not going into the detail, but as the name itself suggests that whenever a data fiduciary is collecting the data, is processing the data, they have certain obligations. Then second principle talks about purpose specification. What for this data is being collected? Suppose that you go to a shopping mall and you are making payment in cash. Still, The storekeeper is asking for your mobile number. What for? Your name. What for? Your date of birth. What for? So it is not the duty of the data principal or data subject. A duty is being imposed on the data collector, that when you are asking for the data, you should specify the purpose. आप किस लिए डेटा मांग रहे हैं? अगर कोई मान लिया कि सेंसस डिपार्टमेंट का कोई व्यक्ति आता है, उसको किस तरह का डेटा चाहिए और वो क्यों मांग रहा है, वो उसको that person, that authority has to explain as to why he is asking for this kind of data. हेल्थ डिपार्टमेंट से कोई व्यक्ति आ रहा है, वो हेल्थ इंफॉर्मेशन मांग रहे हैं, क्यों मांग रहे हैं, किस पर्पज के लिए, क्या यूज होगा इसका, दैट मस्ट बी एक्सप्लेन टू द डेटा सब्जेक्ट हुज डेटा इज बीइंग कलेक्टेड. प्रिंसिपल्स ऑफ पर्पज स्पेसिफिकेशन, जितनी जरूरत है उतना ही डेटा आप मांगिए. पर्पज स्पेसिफिकेशन. डेटा मिनिमाइजेशन, minimum amount of personal data that data fiduciary required to provide services or fulfilling the purpose objectives of the data principle, that should be asked. स्टोर कीपर आपसे कहता है डेट ऑफ बर्थ बताइए. व्हाट फॉर? कैश में आप पेमेंट कर रहे हैं, आपका मोबाइल नंबर भी नहीं मांगना चाहिए उसे, बट वो आपका डेट ऑफ बर्थ मांगते हैं आपसे, कोई स्लिप देते हैं, आपसे भरते हैं विदाउट. सो अननेसेसरी डेटा इज बीइंग कलेक्टेड. और व्हाट दे विल डू विद दैट डेटा, आपके जब भी आपका बर्थडे आएगा, दे विल कॉल यू एंड गिव यू सम ऑफर एंड would offer to celebrate your birthday at their store. Particularly, many storekeeper would do that. So here, this particular principle states that the minimum amount of personal data should be collected, and it must be adequate, relevant, and limited. Information quality. When data has been collected, that data must remain intact. Its integrity should be safeguarded. Like data has been collected and after that some sort of mutilation has taken place. उसमें कुछ distortion होता है जिससे data quality compromise होती है. Principle of disclosure. Data कब disclose किया सकता है? तो उसके principles इसमें दिए गए हैं, OECD guidelines में भी दिए गए थे. तो डेटा का डिस्क्लोजर दो प्रकार से हो सकता है. नंबर वन, with the consent of the data subject, जिसका डेटा कलेक्ट किया गया है उसकी कंसेंट से. दूसरा, बाय द अथॉरिटी ऑफ लॉ. जैसे उदाहरण के तौर पर एक्स की मेडिकल हिस्ट्री या मेडिकल डेटा डिस्क्लोज किया जाना है. हॉस्पिटल कैन नॉट डू इट इट्स ओन. ये तभी डिस्क्लोज होगा जबकि एक्स की कंसेंट ले ली गई है. दूसरा तरीका है कि बाय द अथॉरिटी ऑफ लॉ. मध्य प्रदेश गवर्नमेंट का हेल्थ डिपार्टमेंट ऐसे लोगों की हेल्थ इंफॉर्मेशन हॉस्पिटल से मांगता है जिनको कि कोविड-19 के सिम्टम्स हैं, जिनको फीवर है, कफिंग है, और वो कहता है कि सारा डेटा हेल्थ डिपार्टमेंट को आप शेयर कीजिए. तो यहाँ पर बाय अथॉरिटी ऑफ लॉ स्टेट गवर्नमेंट हैज पावर टू आस्क फॉर दिस काइंड ऑफ डेटा अबाउट द इंडिविजुअल्स. So these are the two ways to disclose the data. There is no other way. And if it is being disclosed without the consent of the data subject or without the authority of law, then it would amount to violation of law. Now, data participation. एक बार डेटा कलेक्ट कर लिया गया. क्या डेटा कलेक्ट किया गया है? जैसे किसी के बारे में कोई इंफॉर्मेशन कलेक्ट की गई है टेलीफोन पर या किसी अन्य तरीके से, तो क्या डेटा कलेक्ट किया, आपने क्या लिखा हुआ है, उस व्यक्ति को पता होना चाहिए. तो डेटा प्रिंसिपल पार्टिसिपेशन स्टेट दैट कि जैसे आपने देखा होगा किसी स्टूडेंट का वेरिफिकेशन के लिए कॉल आता है, तो वो आपसे कॉल करने के बाद जितनी बातें आपने उनको बताई हैं वो उसको रिकॉर्ड करके एक ईमेल आपको भेजते हैं और आपको कहते हैं कंफर्म कीजिए. बिकॉज दे आर ISO 27001 सर्टिफाइड कंपनीज, दे डू फॉलो इट. तो अब उसमें आपने देखा कि ये बात आपने नहीं कही या उन्होंने गलत तरीके से समझ लिया या सुन लिया, तो आप उसको करेक्ट कर सकते हो. दिस इज द डेटा, प्रिसाइजली दिस इज द डेटा प्रिंसिपल, डेटा पार्टिसिपेशन प्रिंसिपल. देन प्रिंसिपल ऑफ इंफॉर्मेशन सिक्योरिटी. सो कॉन्फिडेंशियलिटी, इंटीग्रिटी and availability, that is the scale to measure the security of the information. So it must be adhered. Data must be made available, must be confidential and should be available to the authorized legitimate users, then its integrity must be safeguarded. It must be free from intrusion and any kind of attack. And it must be available to the legitimate users in 24/7 environment. Then a principle of sensitivity. So the information which is being collected, so there are certain informations which are sensitive, like health, religious beliefs, criminal records. So they must be treated differently. But those records which are available in public domain, the privacy rights cannot be claimed in that. Like जेल मैनुअल में किसी की रिकॉर्डिंग है, रिकॉर्ड्स हैं, पब्लिक रिकॉर्ड्स में जो आ जाता है उसको उसमें प्राइवेसी राइट्स क्लेम नहीं होता. We will discuss that case law. Then privacy by design. So there are 7 foundational principles to achieve privacy by design. Proactive, not reactive. Privacy as default setting. Privacy embedded into design. End-to-end security. Full life cycle of the data. Full functionality. Visibility and transparency to keep it so that it must be open for the access to the legitimate users, and respect for the users' privacy. So I'm not explaining these individual points, but I hope that these points are self-explanatory. Now there is another important right, that is right to be forgotten. Now we know that in cyberspace, once you post something, it is stored at various places, and complete erasure of that information is really difficult. For example, एक व्यक्ति, suppose that X is a professor and he was driving the car, और उनको एक सिग्नल उन्होंने ब्रेक कर दिया, उनको पुलिस ने रोका, ट्रैफिक पुलिस ने रोका, उनसे पूछा कि आपने सिग्नल क्यों ब्रेक किया, and then charged him. Or next day it was published in the local newspaper कि a responsible person, a professor, also breaks the traffic rules and was made to pay the fine. ये एक न्यूज एक व्यक्ति के बारे में, एक्स के बारे में पब्लिश हो गई. Now this has been published in electronic form as well. Maybe after the 10 years, that particular person has been or is to be appointed on a very responsible position, और कोई व्यक्ति सर्च करना शुरू करता है कि इनके बारे में खोजे कि क्या है इनके credentials, क्या है इनके achievements. And this information is also available because it was published somewhere. वो information भी flash होती है और उसको लोग highlight करना शुरू करते हैं. कोई उसको social media में post कर देता है कि look at this fellow. What are the credentials? He is not a law-abiding citizen and he is being appointed on such a responsible post. 10 years, 20 years back, it happened. Why it happened? There could be variety of reasons behind that. But somehow, वो news publish की जाती है, वो news highlight की जाती है. Now what will happen to that person? That person would be under pressure, or the appointing authority would be under pressure, or maybe he would lose that position. I'm taking some example, but there are many postings which are available about a person, and maybe he was prosecuted for a particular offense, but later on he was acquitted. जो प्रोसिक्यूशन का है, जब उसको एक्यूज बनाया गया है पर्टिकुलर केस में, वो न्यूज तो बहुत हाईलाइट हुई, बट जब उसका एक्विटल हुआ तो वो कहीं पब्लिश नहीं हुई, वो केवल रिकॉर्ड में है, लीगल रिकॉर्ड्स में है. तो सवाल ये उठता है कि ये सारी न्यूज एक व्यक्ति के बारे में तब भी रहेंगी पब्लिक डोमेन में, एंड वन में लाइक टू प्रोपोगेट इट, यूज इट फॉर देयर ओन पर्पसेस. दैट्स व्हाई राइट टू बी फॉरगॉटन इज वेरी इंपॉर्टेंट, व्हिच सीक्स टू get such data erased about an individual, which is not required. So personal data must be erased immediately where the data are no longer needed for their original processing purpose. The data subject has withdrawn his consent and there is no other legal ground for processing the data. एक व्यक्ति ने एक बार consent दिया कि मैं वाइस चांसलर नहीं बनना चाहता. He was approached and he refused. Now that goes to record. Every time it is being used that he has refused. So when he withdraws his consent that this data about me or my statement, now it should be removed from the database, then it must be. Otherwise, that statement will always be there. So the data subject has objected and there are no overriding legitimate grounds for processing or erasure is required to fulfill statutory obligation under law. Data must naturally be erased if the processing itself was against the law in the first place. जो data collect किया गया, जिसकी processing हुई, वही lawful नहीं थी, then it must be erased. Maybe somebody has published a wrong information, wrong news about an individual. Maybe that professor did not break the rule. So, but still that information is available. So that's why right to be forgotten or right to erase of data is very important, and that is being recognized by the courts in the country, and that has also been taken care in the proposed Personal Data Protection Bill 2019. The case that I had discussed where the lady was a victim of the offense of the rape. So once the case was decided, the father of the girl approached to the court for removal of her name. Why? Because wherever that case would be read, reported, discussed, her name would also appear in that discussion, and that would bring embarrassment to her. So that's why court allowed this. Court allowed this erasure and recognized the right to be forgotten. And this right to be forgotten is important in many other contexts. One context I would like to take: surrogacy. Now, suppose that a surrogate mother, after 20 years, she approaches the child. What will happen? Or maybe that particular child who was born through surrogacy wants to contact. So there are many complex issues relating to this, and that's why this right is to be recognized. Then accountability principle: whosoever is collecting the data must be accountable if it is getting disclosed. What are the legal positions that we will discuss in the next slide? And not only that, when the data is being collected, it must be collected in such a way that wrong information, I mean, who will decide that whatever data that has been collected is correct? So sometimes wrong data is collected. For example, a survey was being made after the independence, that who all are the freedom fighters. This work was given to the police, local police थाना, कि आप पता करिए कौन कौन लोग freedom fighter हैं. एक गांव में पुलिस जाती है, वो पता करते हैं कि हमें फ्रीडम फाइटर जो हैं उनका नाम बताइए, जो स्वतंत्रता सेनानी, स्वतंत्रता संघर्ष में पार्टिसिपेट किए थे. एनएमईटी में दुर्भावना बस कुछ लोगों ने दूसरे का नाम दे दिया, जो व्यक्ति कभी फ्रीडम फाइटर रहा नहीं है. सो पुलिस ने उसका नाम लिखा, उससे पूछताछ की और उसको पेंशन मिली, सारी सुविधाएं मिली. जो वास्तव में रहे उनको नहीं, बिकॉज the way data was collected, that it may yield benefits to the wrong persons or maybe harm to the wrong persons. It may be in both ways. Then this is the UES shield. I'm not going into that. Now, tech advancement and implications. Many technology related advances and related developments are raising questions about their impact on privacy. Few examples could be wearable devices, wearable health devices, smartwatch, household devices, customized advertising, data collection and usage by a business house, mass surveillance by government. Pacemaker, एक 2017 में जो एक अटैक हुआ, उसमें पेसमेकर को कंट्रोल किया गया, because it was being controlled through the computer. So cyber offenses are now being committed, cyber murders are being committed by manipulating the information. So, and this data could be manipulated, and this manipulation of data would have bearing on the human life. Now, there are many technologies which are through which the private information about individual is being collected. One of them is cookies. I do not want to go in detail, but cookie policy. So cookie is a necessary evil. So what is the cookie policy? We consent to that without reading. So if we consent to that, it starts collecting data, and that data could be used, could be processed, and its business use could be made without the permission of the data subject. Similarly, GUI, it also collects information, and it may also violate right to privacy of the users. Webbugs, click tracking, device fingerprinting, web mining, location tracking proxies, RFID. So RFID, like somebody is going to a shopping mall and he is looking on certain articles. He wants to purchase that, but he goes there time and again, touches it, but वो उसको खरीदता नहीं है. You would see that some salesman or women would come to him and would explain him about the payment option and other things. How do they know? How do they come to know about the interest of a person? He thinks that I'm seeing something, I'm examining something, and nobody is aware of it. RFID tags are there. So the moment you touch it, the moment you use it, it gives a message to them. Spywares are being used, which may have a bearing on the privacy of the individuals. Spywares which may come with the legitimate program, like gaming software is being downloaded, along with that a Trojan may be installed. Online digital profiling, we discussed biometric information that is being collected. Now the question is, what are the privacy protection tools? So encryption is one of them, data masking, filtering tools, anonymity tools, VOID, and digital rights management. These are the tools through which the privacy could be enhanced or could be protected. Now, when we look at the regulatory framework, particularly when we talk about the surveillance, so procedure established by law. So that procedure is contained here. Indian Telegraph Act, Section 5 and Rule 419A is to be read together. The Information Technology Act, Section 69, 69A, 69B talks about it, and then certain relevant provisions of the CRPC, Code of Criminal Procedure. Then in 1997, the Supreme Court also gave a guideline on in relation to the interception of communication. That was given in PUCL versus People's Union Civil Liberties versus Union of India. Justice Kuldeep Singh laid down the guidelines for the interception of communication, who can cause interception, and what all procedures are procedural formalities are required to be completed before of that. Then these are the judgments. In this particular case, Kharak Singh versus State of UP, the Kharak Singh was accused of theft. तो पुलिस उसके घर में रोज रात को डोमेस्टिक विजिट करती थी, उनको चेक करती थी घर में है कि नहीं है. So he approached to the court stating that this is violation of his right to privacy, and जो पुलिस को empower करता था, जो provision यूपी पुलिस रेगुलेशन एक्ट 236 क्लॉज बी, सुप्रीम कोर्ट ने उसको अनकॉन्स्टिट्यूशनल डिक्लेयर कर दिया कि दिस पर्टिकुलर प्रोविजन इज हिटिंग द आर्टिकल 21 ऑफ द कॉन्स्टिट्यूशन, और ये पुलिस इस तरह से किसी के प्राइवेसी राइट्स पर को इनक्रोच नहीं कर सकती. In Rajgopal versus State of Tamil Nadu, right to privacy was held to be implicit in Article 21, and a citizen has right to safeguard the privacy of his family, marriage, procreation, motherhood, childbearing, and education, among many other matters. Right of a prisoner to privacy was also recognized. This was the first case जहां पर prisoner के right to privacy को भी recognize किया गया. Then state versus Charulata Joshi. Freedom of the press is not an absolute right. The press must first obtain the willingness of the person sought to be interviewed, and no court can pass any order if the person to be interviewed expresses his willingness. Press किसी व्यक्ति को फोर्स नहीं कर सकती इंटरव्यू देने के लिए, अपने आइडियाज शेयर करने के लिए किसी इंसिडेंट पर, और कोर्ट भी कोई ऐसा ऑर्डर पास नहीं करेगी कि एक व्यक्ति को फोर्स किया जाए इसके लिए. सो दिस वाज गिवन इन द चारुलता जोशी केस. एक्स वर्सेस हॉस्पिटल जेट. इस केस में क्या होता है कि देयर वर टू पर्संस, अ बॉय एंड गर्ल, दे गॉट एंगेज्ड, दे वर अबाउट मैरी, और उसी समय द गर्ल, द फियांसे गॉट टू नो दैट हर प्रोस्पेक्टिव हस्बैंड इज विजिटिंग हॉस्पिटल टाइम एंड अगेन. तो उसने हॉस्पिटल में जाके पूछा कि ये हॉस्पिटल में इनको बीमारी क्या है, बिकॉज दैट पर्सन वाज नॉट टेलिंग हर. सो हॉस्पिटल ने पूछा कि आप कौन है. सो सी टोल्ड दैट आई एम ए प्रोस्पेक्टिव वाइफ, हमारी एंगेजमेंट हो गई है, वी आर गोइंग टू मैरी. तो हॉस्पिटल ने उसको ये डिस्क्लोज किया कि दिस पर्टिकुलर पर्सन इज HIV पॉजिटिव. नाउ द मिस्टर एक्स, he approached to the court stating that hospital had violated his right to privacy, which is a fundamental right guaranteed under Article 21. सुप्रीम कोर्ट ने इस मामले को सुनना शुरू किया और जस्टिस BP जीवन रेड्डी ने इसमें अपना ऑब्जर्वेशन दिया कि यहाँ पर दो फंडामेंटल राइट हैं. पहला फंडामेंटल राइट क्या है? राइट टू प्राइवेसी ऑफ मिस्टर एक्स, कि उनकी मेडिकल हिस्ट्री हॉस्पिटल ने क्यों डिस्क्लोज किया. दूसरा फंडामेंटल राइट है ऑफ हिज फियांसे, उसका फंडामेंटल राइट क्या है? राइट टू नो अबाउट द गुड हेल्थ ऑफ द प्रोस्पेक्टिव हस्बैंड. तो यहाँ पर क्लैश है, देयर इज अ क्लैश बिटवीन टू फंडामेंटल राइट, राइट टू प्राइवेसी एंड राइट टू नो. सुप्रीम कोर्ट ने कहा कि राइट टू प्राइवेसी इज नॉट एन एब्सोल्यूट राइट, एंड इफ देयर इज अ क्लैश बिटवीन टू फंडामेंटल राइट, दैट इज राइट टू प्राइवेसी एंड राइट टू नो, then that fundamental right shall prevail which is in the public interest. तो कोर्ट ने कहा कि यहाँ पर इस मामले में हॉस्पिटल ने जो डिस्क्लोजर किया है वो जस्टिफाइड है, क्योंकि ये प्रोस्पेक्टिव वाइफ हैज एवरी राइट टू नो अबाउट द गुड हेल्थ ऑफ हर प्रोस्पेक्टिव हस्बैंड. सो दिस डिस्क्लोजर वाज जस्टिफाइड. नाउ बॉडीली प्राइवेसी की हम बात कर रहे थे, तो सेक्शन 66E ऑफ द इंफॉर्मेशन टेक्नोलॉजी एक्ट, इट क्लियरली स्टेट दैट कि अगर किसी व्यक्ति का कि शारीरिक निजता का उल्लंघन हुआ है तो इस पर्टिकुलर प्रोविजन के तहत सजा का प्रावधान है. 3 साल तक की सजा हो सकती है, फाइन भी हो सकता है. और इसमें कहा क्या गया है कि कोई व्यक्ति इंटेंशनली और नोविंगली, जानबूझ करके या नॉलेज के साथ कैप्चर्स, पब्लिशेस और ट्रांसमिट्स, कैप्चर करता है, पब्लिश करता है. पब्लिकेशन का एक जो ऑनलाइन और ऑफलाइन वर्ल्ड है, उसमें पब्लिकेशन में एक ह्यूज डिफरेंस है. डिफरेंस ये है कि जब हम पब्लिकेशन की बात ऑफलाइन वर्ल्ड में करते हैं तो कोई प्रिंटर होगा, फिर कोई उसे पब्लिश करेगा, एंड देन इट वुड बी सर्कुलेटेड. ऑनलाइन में क्या होता है कि द मोमेंट वी अपलोड ए फाइल, दैट वेरी मोमेंट इट हैज बीन पब्लिश्ड, इट हैज बीन डिसेमिनेटेड एंड इट हैज बीन स्टोर्ड एट मल्टीपल लोकेशंस इन मल्टीपल सर्वर्स. ट्रांसमिशन का मतलब इस प्रोविजन में यह है कि अगर किसी व्यक्ति ने किसी दूसरे व्यक्ति के जो प्राइवेट एरिया ऑफ बॉडी है, प्राइवेट एरिया ऑफ बॉडी ऑफ पर्सन, उसका फोटोग्राफ किया है, वीडियो बनाया है, उसको कैप्चर किया है, उसको ट्रांसमिट करता है, इज पुटिंग इन द मोड ऑफ ट्रांसमिशन. अब एक सवाल यहाँ पर ये भी उठता है कि somebody has put something in, somebody has put a photograph of private area of a person in the mode of transmission, लेकिन ये कभी पहुंचता नहीं है, it is lost during transit. तो ये प्रोविजन कहता है कि अगर आपने भेज दिया है अपनी तरफ से, वो भले ही दूसरे व्यक्ति तक ना पहुंचे, तब भी ये ऑफेंस माना जाएगा. So a person who is expecting reasonable level of privacy in a particular circumstance, for example, एक व्यक्ति जो अपने घर में है, अपने रूम में है, जैसे एक केस में कोई ड्रोन फ्लाई कर रहा था, अब ड्रोन उसने एक मल्टी स्टोरी बिल्डिंग फ्लाई किया और एंड इट कैप्चर्ड, it made a video of a couple who were in their room. Now the question is, will it come under section 66E or not? So the case was booked under section 66E, but we have to see whether what would be the decision of the court, because that other party is claiming that it was not an intentional act. We were just flying drone, we were just trying it, but that accidentally captured or suited that video what was going in the room. So circumstances where a person would expect reasonable level of privacy, changing room, trial room, his home, public toilets, private spaces, as well as in hotel. If a private hotel is not a hotel is a public place, but a room in hotel is private place. So if a person does that, he would be liable here. So regulatory framework for data protection, this is the important provision, section 43 capital A. It talks about the liability of the body corporates. If any body corporate has collected some information and it has been negligent in storing that, जैसे एक सर्विस प्रोवाइडर ने आपका डेटा कलेक्ट किया, सेंसिटिव पर्सनल डेटा इन्फॉर्मेशन, एंड देन उसके डेटाबेस से लीक हो जाता है और वो ये कहता है कि मेरी कोई जिम्मेदारी नहीं है, मैंने सारा आई हैव टेकन ऑल द प्रिकॉशंस, आई हैव एम्प्लॉयड ऑल द सिक्योरिटी सॉल्यूशंस टू प्रिवेंट एनी काइंड ऑफ लीकेज, तो यहाँ पर उसकी लायबिलिटी बनेगी और उससे कंपनसेशन प्राप्त किया सकता है। सेक्शन 72 कहता है कि अगर किसी व्यक्ति ने किसी सर्विस प्रोवाइडर ने, इंटरमीडियरी ने जानबूझ करके डेटा को लीक किया है, तो यहाँ पर उसकी क्रिमिनल लायबिलिटी होगी। अब यहाँ पर आप देखेंगे 43 कैपिटल ए और 72 कैपिटल ए में डिफरेंस क्या है, सॉरी 72 कैपिटल ए में डिफरेंस क्या है कि एक पर्टिकुलर इंटरमीडियरी है, से फेसबुक में employ all these practices, may collect and transfer the data. When they would be caught, they would pay the compensation. It is a big company, तो वो compensation individual को pay कर देंगे. So that's why यहाँ पर criminal liability की बात की है। अगर कोई जानबूझ कर कोई इंटरमीडियरी किसी डेटा सब्जेक्ट के डेटा को लीक करता है जो कि उसको सप्लाई किया गया था फॉर ए पर्टिकुलर पर्पज, जैसे मैंने सिम कार्ड लेने के लिए अपना डेटा किसी को दिया, तो वो डेटा किसी को लीक किया जा रहा है, तो उस केस में ऐसे इंटरमीडियरीज की लायबिलिटी बनेगी और उनकी क्रिमिनल लायबिलिटी भी होगी। तो 43 कैपिटल ए के तहत कॉम्पनसेशन प्राप्त किया सकता है एडजुडिकेटिंग ऑफिसर के पास जाकर के, एंड 72 कैपिटल ए के तहत उसकी क्रिमिनल लायबिलिटी बनेगी। नाउ विद दिस आई वुड लाइक टू conclude. If there are any questions, comments, I would be happy to take that.